Hi guys, this is Scott Horne of the Owner Finance Network. We're going to take a minute in this video. We're going to talk about just things that pop up when you're buying properties that are inherited. So someone's passed away and you're negotiating with an heir, maybe it's with an executor of estate. They're just things you got to be understand about this, think about a little bit as you're moving forward to take care of your issues. So if you find the video helpful, guys, take a moment and like it, please. Don't forget to comment. We'll do our best to answer those for you. And flop over to our YouTube channel and join. Hopefully you'll find a lot of good information there for you. So buying properties from somebody who is deceased. I guess we're not buying it from the deceased person. It'd be kind of hard, but from their heirs or their estate. So just basic things you got to know. Most states have well, let's just back up. Most people don't have a will. And so you're following the state's estate code or probate code in that instance under the laws of what we call our intestate succession. That means if the husband dies, it goes to the wife, or does it go to the kids, or does it go to brothers and sisters or parents or whatever it might be. And I'll tell you, it's worthwhile taking a moment to learn at least the first 3 or maybe even 4 layers of that because it helps you navigate the conversation when you're working with properties of this nature out there. But people think that just because there is a will and there's an executor that's naming that will, that executor controls the transaction. Absolutely not. First and foremost, you've got to decide, can that will even be probated? For instance, here in Texas, we have a 4-year statute of limitations. If you've gone beyond that since the person passed away, you ain't probating that will. Other states are probably the same, so you should make sure you know what that statute is. The other thing that arises is you'll talk with people who say, oh, I'm the executor of the estate. And you're going, great. So you filed the will with the court. Well, no, but I'm named as the executor, so I'm allowed to do everything. No, you're not. A will is nothing more than a piece of paper until such time as it has been filed with the court and that the court has appointed an executor and sworn them in that scenario. Now you're probating the will, and the executor, the executrix, the administrator, whatever word you want to use for them, they are now empowered to act on behalf of the state. And if it has actually gone that far, you want to be asking for that person's letters testamentary. I know that sounds weird. I don't know where that word actually came from, but they're called letters testamentary. And that is the document that empowers the executor to navigate things on behalf of the estate. So once you get past that hurdle, of course, so often we're dealing with non-probated property, meaning it's never gone through probate, there's no will. So now we're dealing with, the laws of intestate succession. So you need to find out what the rules and regulations are in your state regarding what we call heirship. It's an affidavit that is used very commonly in the real estate world that defines the person's life, marital statuses, children, things of that nature, real estate, and then it's sworn to by the affiant, and then there are at least usually 2 witnesses that corroborate that affidavit. Most states will work with you on heirship affidavits, which is a great way of handling things and a little bit quicker off time than the probate. So get some basic understanding of the laws of intestate succession in your state. Learn the basics about a will. When is it a will? When is there really an executor involved? And how is that handled versus the heirship affidavit? So once you get to that level, if you're dealing with someone who is a legitimate executor of the estate, that's great because they make the decision, they sign your contract, they sign the closing paperwork, and you're done. You don't care whether there's 1 heir or 400. On the flip side, if you don't have that, now you're dealing with the heirs, and you've got to determine, 1, who are the heirs? Are they of majority age, over 18 or not? Is there 1 heir or 10 heirs? And then you look and you go, well, if there's multiple heirs, are they all still alive? Awesome. And from there, you start to navigate these transactions. Let me just kind of run a few examples past you real quick. Handled a situation not long ago where a sister had passed away. Mother and father had died years and years and years ago. And she had 9 surviving siblings, and 3 that had passed away. And so, understanding that, when you do the heirship affidavit, you've got the 9 surviving heirs, but now you've got to do an heirship affidavit for the 3 deceased brothers and sisters. The question then becomes, do they have any children? Well, in this case, the answer was yes, they did. And one of those children had predeceased their parent. So now you've got to do an heirship affidavit for that predeceased child, who in most cases probably doesn't have any heirs or children. But you have to think through this and navigate that appropriately, because now, for instance, in this case, you had 12, 13, 14, 15 heirs who all in some format had to execute a contract in order to buy the property. So you've got to take a moment and just think about those things. In another situation, in fact, I was dealing with this on the way to this session today. Um, a father and daughter were unfortunately in a car accident and killed simultaneously. And again, guys, this is Texas law. This is not for other states. You got to understand to check your state and how this may or may not work under your laws of intestate succession. And it was a simultaneous death. So what happens? Well, at first blush, you would think that the wife of the husband would get everything in this scenario. And in fact, the underwriter of one of our title companies said, yeah. Well, something didn't sit right with us. We didn't like that. So we resubmitted it back to them. And sure enough, we were right. The wife, in this case, this was wife number 2, got half the property, and the daughter would get the other half of the property because there was a prior marriage here in Texas. But that daughter, of course, had passed away, and she has 3 children who are minor children. And so here you're thinking you're ready to make this deal, get it sold, and all of a sudden, boom, the brakes get put on. Now you got to go back and start navigating all of this over again. So often in our investment industry, I see so many people who there might be 3, 4, 5 heirs, and they get one signature, and they're thinking they've got a deal. And they run down to the title office and turn it in. Or they turn around and they file a memorandum of contract when they don't even have a valid contract yet. And they're trying to muddy the waters and tie things up, but at the end of the day, you're creating a problem that could probably be actionable and you can be sued on for filing improper liens or clouding title on a property without everybody agreeing to sell. So it is so important to get a good grasp, try to organize everybody at once if possible. And so we run into more issues down the line. If you have 4 heirs out there, let's say, they're each going to divide up the net proceeds of your purchase, maybe 25%, 25%, etc. Well, what if one of those heirs has an IRS lien against them, or a judgment lien, or a child support lien, or something else? What happens then? Well, bottom line is at the closing table, their 25% of the net proceeds is going to go to pay those judgment liens, IRS liens, whatever it might be, first, and they get what is left over. So often they wind up with 0. Well, when you do that, all of a sudden, they don't want any part of this. They don't want to sign the contract. It's like, I'm getting nothing, I'm walking away. Not always, but sometimes. Here in Texas, heirs can execute a waiver of interest. Awesome. What he and his brothers and sisters do later on, whatever it might be, I don't care. But they can execute a waiver of interest in a property. That might be a solution to a problem like that. Not always. But it is certainly something that's optional out there. And you wanted to walk through these things and be able to look at this as it pops up, because we as investors are the ones that are usually tasked with handling these issues. Your title company, if you're closing in a title company, isn't going to talk to the heirs about this, because at that point in time, you're retaining an attorney, usually one that works with or for that title company, to handle the heirship issues for the seller. And maybe they need you to help to communicate better with these buyers, sellers along the way to put this thing together. It's a lot of fun, by the way, guys, going after the probate properties, if you understand how things work, the flow of intestate succession. Who am I talking to? How can I better put this deal together? How can I get people to help here or there? Because so often there's this thing floating around that's called buying a partial interest in a property. Well, that can become very difficult also because it may and usually would entail filing a lawsuit against somebody in order to get their interest, or filing what we call a partition lawsuit, which is asking a court to sell the property. And all sorts of various issues come out. A lot of people want to think about what we call adverse possession. And oftentimes you cannot adverse possess against another heir of a property. And so the question is do we file a lawsuit? Do we do a partition action? How does that work? What does it look like in the event you have these heirs where you might have 5 heirs, 3 want to sell and 2 don't? Sometimes, guys, when you can go buy the interest of those first 3 heirs who want to sell, you get the problems out of the way, whatever those problems might have been, and you're able to negotiate the final sale with the other 2 heirs. But not always. Oftentimes, you'll find that one of those heirs is living in the property. They're living for free. They're not paying taxes. There is no mortgage payment, or they're not paying the mortgage payment. And they're basically freeloading off of all their brothers and sisters. And that happens so often. And the question becomes, how can I navigate that and get through it all? Maybe one day we need to have a video on partitioning and navigating these situations and look at it. But when you look overall at the probate process and acquiring properties, the first thing I have to recommend you guys do is get that modicum of knowledge. What type of estate are you in? Talk to that knowledgeable probate lawyer. Understand what a will is, what an executor is, when that actually becomes a legitimate executor. What paperwork do you need? Learn the basics of your intestate succession in the state where you're located. How does that work from level 1, 2, 3, 4? You don't need to go all the way down the chart, but just getting a basic knowledge will help you have those conversations with those sellers who are heirs and navigate through the transaction from a monetary perspective. And again, so often I find that playing the probate game, having a good working knowledge of it, helps me buy a lot of houses, and oftentimes at a much cheaper rate also. So guys, I hope you found this video helpful. If you did take a minute and like it, please don't forget to make any comments. We'll do our best to get to those. And go visit our YouTube channel at theownerfinancenetwork.com, and we'll see you guys next time.